Are you taking the solicitor's qualifying examination? If so, this video is a practice test question to help you prepare for the SQE1 exam. In this part of the course, we're going to cover what you need to know for the SQE1 exam about the interpretation by courts under the Human Rights Act. I will explain this topic in an easy to learn diagram, which you can see here, and we'll then go through this practice test question together from the SQE1 exam for this topic. To get the first part of our full SQE preparation course for free, just click on the link in the description below. My goal is to help you prepare for and pass the solicitor's qualifying examination first time. Section 2 reads as follows. Interpretation of convention rights. A court or tribunal determining a question which has arisen in connection with a convention right must take into account any judgment, decision, declaration or advisory opinion of the European Court of Human Rights. So this means that if there is a question which has arisen in connection with a convention right, the judge must take into account Strasbourg case law before arriving at his interpretation. So now we're going to have a look at interpretation of legislation under Section 3 of the Human Rights Act. This section requires legislation, both Acts of Parliament, primary legislation, and secondary legislation or subordinate legislation, to be interpreted so far as possible so as to be compatible with the Convention. The previous rule was merely that courts would take the Convention into account in resolving any ambiguity in a legislative provision. But the courts are now required under the Human Rights Act to interpret legislation so as to uphold the Convention rights, unless the legislation itself is so clearly incompatible with the Convention that it's impossible to do so. This rule of construction applies to past as well as to future legislation. Interpretation of legislation. So far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. This section applies to primary legislation and subordinate legislation whenever enacted. Now I'll have a look at declarations of incompatibility under Section 4 of the Human Rights Act. This section permits the courts to declare that legislation is incompatible with a convention right. This declaration of incompatibility is made if the courts decide in any case that it is impossible to interpret an Act of Parliament in a way which is compatible with the Convention. This power is reserved to the higher courts, and a declaration that legislation is incompatible with the Convention rights does not of itself have the effect of changing the law, which will continue to apply. So primary legislation is not struck down or set aside by a declaration of incompatibility. However, it will almost certainly prompt the government and parliament to change the law. So the courts do not have the power to set aside primary legislation, past or future, on the ground of incompatibility with the convention. And this enables parliament to continue to be sovereign, so Parliament is competent to make any law on any matter of its choosing. The position is different with secondary legislation such as statutory instruments. The courts may strike down or set aside secondary legislation which is incompatible with the Convention unless the terms of the enabling statute make that impossible. The courts can already or could already, before the Human Rights Act, strike down or set aside secondary legislation if they considered it to be outside the powers conferred by the statute under which they were made. And the Human Rights Act simply extends that ability to when secondary legislation is incompatible with the Convention rights. Section 4 reads Declaration of Incompatibility. If the court is satisfied that the provision is incompatible with a convention right, it may make a declaration of that incompatibility. A declaration under this section, a declaration of incompatibility, does not affect the validity continuing operation or enforcement of the provision in respect of which it is given. So here is a sample question of the kinds that you may get in the SQE1 exam. What is the correct position in law under the Human Rights Act? A. So far as it is possible to do so, primary legislation and subordinate legislation must be declared to be compatible with the Convention rights. B. So far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. C. So far as it is possible to do so, primary legislation must only be read and given effect in a way which is compatible with the Convention rights. So far as it's possible to do so, subordinate legislation must only be read and given effect in a way which is compatible with the Convention rights. The correct answer is B. So far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. I hope you found this useful. To get the first part of our full SQE preparation course for free, just click on the link in the description below.